99% they will abide by the solution. Bring the solution on board because they know they will abide by the solution, unlike the outcome. And so, in moving forward, arbitration has played a very vital role in commercial transactions, particularly international commercial arbitration, even domestic arbitration. And therefore, at a point in time, because of the involvement of lawyers, because of the misconception of ADR itself, the antagonism that arbitration has been witnessing has slowed down the mechanism, relegating it to the point of becoming a stepping stone to litigation, which it's not supposed to be. It is not supposed to be like that, but unfortunately, we have found ourselves in that position. And therefore, we saw another development where people would prefer to get a mediator, mediate their matters, and then go into court and take it as consent agreement. And then it was being signed as a contract. Like I said, that the society is becoming more and more complex. We have to match up with the complexity of the society. We realize that the most important thing about conflict resolution is for parties to resume their relationship, particularly when it is business relationship. Now, mediation thrives on collaborative communication. It thrives on consensus building. It thrives on mutual understanding. And when we have collaboration, consensus building, understanding, the absolute end result is that conflict is minimized to the barest minimum. Because mediation is party-driven, the procedure where decisions are made by the parties themselves rather than by the neutral third party, like I said earlier on, creates an environment where the obligations by the parties is being met and they also abide by it. So people are becoming more and more aware of the alternative of mediation as against arbitration and litigation. In arbitration, we usually say that arbitration is cheaper than litigation. But however, it depends from which angle it is being viewed. And we realize that non-state players have also brought in so many things that even when you have an arbitration award, especially under the ACA, the Arbitration and Conciliation Act of Nigeria, where the award could be challenged on grounds of misconduct. And we know that parties who are not ready to abide by the outcome of the award will always run to court and challenge the award on grounds of misconduct. And the word misconduct, what is misconduct, what is not misconduct, the moment an award is being dragged to court for challenge on that misconduct, it ends up going back to the litigation, to the court system. But thankfully enough, the Arbitration and Mediation Act of 2023 has removed that ground of challenge. So I think arbitration has gotten another leg to stand on. But in mediation, so long as you enter into an agreement, both have signed, and you have submitted it as your consent agreement between you and your party, it is being endorsed, and all the grounds of whether it is gross, in fact, there is even no challenge to it. And so we realize that the coming of the Mediation Act, as I will not talk much about that because Fola is here, he will talk much about that. But I'm specifically talking about the position of mediation, whether mediation is a weakling in comparison with arbitration. For this moment, and with the way conflict is being resolved and with the way conflict is going internationally, we have come to the realization with the Singapore Convention that the better option to dispute resolution is mediation, especially commercial dispute resolution, international commercial dispute resolution. The Singapore Convention highlights mediation's ability to allow resolutions adapted to the particular situations of conflict and demands of parties, emphasizes the significance of mediation in international trade. Therefore, mediation is not a poor cousin to arbitration. From all that has been happening in the world today, we can see that mediation is becoming the elder brother of arbitration. Why did I say that mediation is becoming, or it's already the elder brother of arbitration? In mediation, your skills of mediation based on Singapore Convention, if you to move from arbitration to mediation, especially when you are a sole arbitrator, up med and med up. So if you don't have mediation skills, you only have arbitration skills, the possibility is that you may lose out on most of the cases that may confront you, because most parties they are in the transaction, particularly trade, commercial transactions, and they will not want any waste of acquisition of skills, mediation skills to be particular, helps you to navigate between arbitration and mediation, and you will land safely. Mark Walcott backed the idea that its rise to prominence is a testimonial. That is, I'm talking about mediation now. Its rise to prominence is a testimonial to the varied, nuanced, and complicated nature of conflict in modern society, rather than a criticism of arbitration. Rather than a criticism of arbitration, we're not here to criticize arbitration. We're here to add flesh to our dispute resolution sphere. So together, arbitration and mediation play separate but complementary roles in conflict resolution environment. Therefore, mediation is not inferior, but rather more practical way to resolve conflicts, easy and affordable, accessible by all parties, both regular citizens, business partners, domestic arrangements. You remember that when it comes to arbitration, there are restrictions on matters that can go for arbitration. But in mediation, there is a varied sphere where conflicts could be resolved through mediation, especially domestic issues, family matters. Perfectly, you can use mediation to resolve family conflicts and even commercial conflicts, particularly in the recent environment we find ourselves. So, the Nigerian Arbitration and Mediation Act 2023 has eliminated conciliation and replaced it with mediation, because conciliation, it's more or less like arbitration. If you look at the appointment of conciliation, it's the same way you appoint conciliators, the same way you appoint arbitrators, and so on and so forth. So they have similar working framework. But with the coming of mediation being passed into law, we can confidently and comfortably engage ourselves and work towards having multinational conflict being resolved by mediation, and it becomes binding and enforceable even in international arena. Thank you very much for listening. I would like to give the floor to our resource persons to give us nuggets of their wisdom, and then we'll go to the induction proper. Thank you very much.
Thank you very much for this wonderful session. We appreciate you, Mal, for sharing with us, and we are grateful. So, without waste of time, let me call on Mr. Fola to give us his own thoughts in respect to his own topic. Mr. Fola, you have the floor. Mr. Fola, you have the floor. You are muted, sir. You are muted, sir.
Okay, yeah. Sorry about that. Yeah, I couldn't unmute myself. Thank you so much. So
that's what I want to say. Sorry, the admin, please. I think you should allow the resource persons. Thank you, Mr. Fola. You can go ahead. We can hear you.
Okay, thank you so much, Mr. Ankama, for a beautiful presentation. And with your kind permission, I will be speaking on my topic for today, and I was told to do a presentation on the implication of the Nigerian Arbitration and Mediation Act of 2023 and what the prospects are. But before I delve into this topic, I'm constrained to want to talk about today's topic about mediation being a poor cousin of arbitration. And in most of the places I've had cause to present, I always ask why there should even be a comparison in the first place. You know, why are we comparing mediation to arbitration? Why? Because if we look at it's comparisons like this that bring about some sort of dichotomy in the dispute resolution ecosystem. And I'll explain. If we look at the umbrella of arbitration, mediation, conciliation, negotiation, they all come under the umbrella of alternative dispute resolution, each having what they do. You know, arbitration is, of course, definitely a preferred mode of dispute resolution where most commercial cases are. But we have some other cases that are not that commercial. So then we have mediation, we have conciliation. So one thing I've always tried to advocate for, especially where ADR is concerned, is that why don't we have a scenario where it's almost like some kind of, it's almost tantamount to the multi-door house concept, where you try negotiation. If negotiation doesn't work out right, then you try mediation. If mediation doesn't work out right, then you try arbitration. You know, that way we're all working together, you know, as opposed to having comparisons between arbitration and mediation. You know, I just couldn't resist the urge to just drop my 50 cents on that. So before I go into my paper for today, so essentially I'll just, because I have just 15-20 minutes, just talk about some highlights from the Nigerian Arbitration and Mediation Act. Now, ladies and gentlemen, something, you know, the geometric rate at which mediation is moving forward, to say the least, is amazing. Because I remember when I started mediation less than 10 years ago, I knew how it was then. I knew how mediation was 2 years ago, and I know how mediation is right now. it is moving at an amazing speed. So much so now that with the introduction of the Arbitration and the Mediation Act, I'll just pick on salient on some provisions for the sake of time. So it's essentially covered by Part 2, and you have the sections from section 67 to 87. There are just 20 sections. So I'll please admonish everyone, when you are less busy, to please try and read it. So essentially, what section 67 sub 1 talks about just applies to both domestic and international commercial mediation proceedings, to the effect now that the settlement agreement that you enter into here in Nigeria can be used in other countries. Now, another interesting innovation, well, which has always been in existence really, is the fact that the AMA is now recognizing online dispute resolution as the mode of dispute resolution, for want of a better way to put it. Now, the beauty about the connection mediation has with technology is almost seamless, because you see, ladies and gentlemen, we're in an era of technology, to the effect that if you have any business you're going into and that does not have an infusion of technology, I can tell you that very soon it's going to become the relic of a lost age. So the seamless connection mediation has with technology, to the effect that I'm here in Nigeria, Lagos to be precise, Nanchang is in Kaduna, and we have so many of you from all around the world. We are here on one platform now. Shows the interesting development, you know. And the beauty about it right now is that with the rate at which infusion of artificial intelligence into mediation, to the effect that I can be here in Nigeria myself to some kind of virtual room, and I have parties there, and then we can mediate. So the section 73 sub 5 also lend credence to the fact that with online dispute resolution, you can actually have disputes resolved via electronic means, such as video conferences and whatnot. And another interesting innovation development of AMA is section 73 sub 6, which says that, which gives mediators the mandate to make proposals towards settlements. But I must also add that the proposals made by mediators are not the type that should be imposed towards settlement. I'm sure when a lot of us were trained to become mediators, we were always told not to we should always allow the parties more or less dictate the tone. Now, but let's remember that we have different styles of mediation. We have the evaluative and we have the facilitative. So what section 73 sub 6 essentially is saying is that as a mediator, you can actually guide parties towards an amicable resolution. And I remember some time ago, like from 4 years ago, a mediator approached me and told me that he was subpoenaed by one of the parties when one of them did not keep to the terms of the agreement. So the interesting development of section 77 of AMA states that a mediation proceedings cannot be, first of all, a mediator, so that, which is section 81, has immunity to the effect that he or she cannot be held liable for any act committed, for as long as it was not done in bad faith, and also to the effect that mediation proceedings cannot be admissible as evidence in any arbitral, judicial, or administrative proceedings. So these are very unique sections that I would please crave the indulgence of everyone to please have a look at. Now, section 82 sub 2 has also put paid to the misconceived and the mischievous notion that mediation is not binding. So section 82 sub 2 clearly states that mediation is binding and enforceable as a contract, consent award, and as consent judgment. Because I remember back then when we would always train on mediation, some of the pain points or questions that always come up would be that mediation is not binding. And I always ask a simple question, that the end product of a successful mediation session is the terms of settlement. A term of settlement is a contract. Is a contract not binding? You know, so and that's why, and this also brings me back by way of digression to the topic of the theme of the session, where inferences that are being made through comparing one method of dispute resolution to another method of dispute resolution. I feel that we should all try and work hand in hand and not see ourselves as being in competition with each other. And Section 87 also talks about international settlement agreements as being enforceable in Nigeria, and the laws of the Convention on International Settlement Agreements resulting from mediation. So there are so many interesting provisions in AMA that I really would have loved to go into, but for the sake of time, I can't do much more than that. But I'm going to leave all the inductees with one word. I'm going to first of all congratulate them, because you see, when I mean congratulating, well, I say that because the times are changing, you know, and the way times are changing, the mindset of disputants are changing, to the effect that, you see, back in the days, you can actually tell a client that you filed your case in court, you've done all you need to do. Ladies and gentlemen, it is no longer about effort now, it's about results. The mindset of the 21st century client is result driven. You know, it's no longer about the effort. And what technology, you see, what innovation is doing is that as fast as innovation is moving on, it's also coming up with its own problems. Its problems to the effect that, and the problems are somewhat hydra-headed. You know, right now we're talking about artificial intelligence. Artificial intelligence also has its own problems. And the biggest selling point for mediation, there are three actually. Number one is speed and efficiency. Number two is the possibility of the restoration of a business relationship. And one thing that we're also not looking at again is the global appreciation of mediation, to the effect that, just look at what's happening right now, ladies and gentlemen. You know, some of us from across the world, we are here under one umbrella, having a conversation about it. And you see, and another thing that's happening now that I don't think a lot of people are aware of is that, you see, mediation is now opening the door. Not even mediation, ADR is opening the door to non-lawyers to come in to have the dispute resolved, to the effect that you don't have to be a lawyer before you get into the ADR space. And some of the best mediators and arbitrators that I've met, a lot of them are not lawyers. So you see, we lawyers need to be very careful not to see the ADR as something that just belongs to lawyers alone. It does not belong to lawyers. So that's all. That's the much I can say right now. And I also want to congratulate Mr. Nanchang. And I've said this because I remember when I came to Kaduna and I met Mr. Nanchang, and I told him one thing. I said, Nanchang, the way that you are going, you're going to become, quote unquote, the king of the north, because this is a man that is filled with vision. Here is a man that sees the benefits of mediation, and in his own way, he's trying to make a change. Thank you all for your time, and God bless.
Thank you very much, sir, for this that wonderful session. Can you hear me?
Yes, we can hear you, Mr. Nanchang.
Thank you very much for that session. I really appreciate. Mr. Fola has been my mentor. And when it comes to the issue of mediation, it doesn't take things that easy. I remember the first training, first virtual training we did, and then he brought us as mentees. And the kind of rebuke he gave us, it was like, I feel like actually opening the grounds and just disappearing. But I believe that actually had a serious impact on me and some of the things that I do. Thank you very much, sir. We really appreciate you. Kathleen, you give us your perspective on, we are looking at the implication of the Singapore Convention on member states in the light of what we are discussing. So over to you, Kathleen.
Thank you so much. And first of all, congratulations to everyone. Secondly, it's a pleasure to be here. And for the speakers before me, it's very nice to follow in your footsteps. And I would like to talk about the Singapore Convention and mediation not being the poor cousin to anyone. Mediation is not an inferior process to anyone or anybody. So in regards to the Singapore Convention, It's a multilateral treaty for settlement, international settlement agreements in regard to commercial disputes. So the beauty of sitting at that mediation table and hammering out these commercial disputes resulting from mediation, the countries decided that we needed a flow. We've worked so hard at the mediation table. We've made so many agreements in regard to commercial disputes. How about we introduce some fluidity to what we worked so hard about and let these mediation disputes cross through countries without being remediated or without being sent to court to have the court determine their values. So with that wonderful goal in mind, there's certain things the Singapore Convention does not cover. The Singapore Convention on Mediation doesn't cover family matters, doesn't cover inheritance matters, it doesn't cover employment law right now. And it also doesn't cover disputes with only one consumer. So back in, as it was mentioned already, September 2020, this was ratified by 11 countries across our globe. And it was signed by 55 countries, and it has not been signed by other countries. The United States was an original signatory, and I have this wonderful story. Even though we are a signatory, it hasn't been submitted to the Senate yet. And I have this wonderful story about a friend of mine who's friends with Delcy, who is one of the drafters of part of the literature, the drafting on the Singapore Convention. And they were all in New York City before the convention, and they were working really, really hard on getting the last minute drafting done for the convention. And there was a huge snowstorm that dropped down into the city and turned off the power. So they finished doing their drafting by candlelight, by flashlight, by cell phone lights, so they would be on time for the timing for the convention. So with this wonderful ability, the object agreed to it, but ratify it to make sure that as we work so hard at the table, especially in commercial disputes, business disputes, that these agreements can be seamless as they enter other countries. And I think that is a beautiful thing, because we are not a poor cousin of arbitration, because when people come to the commercial mediation table, as any mediation table, everyone has a fully empowered voice. And if I could share my screen for a moment, if I could be a co-host, possibly Nanchang, I can show you exactly where we belong in the ADR spectrum. Let me see if I can share my screen here. Not yet. Nanchang, is it possible for me to share my screen quickly? We are in our own location in dispute resolution, which is now being called, instead of alternative, the word that's coming out is appropriate dispute resolution instead. And yes, here we go. Let me show where we are here. And which I think is a nice name, very much so. And no matter what we're trying to do here is we're trying to have a conversation around the mediation table. And where we are, let me just make this, where we are here in mediation, to the right is all our adjudicative processes that we have, especially in the United States. Over on the right side under adjudicative, and there are mediators as well that are hired to be a bit of adjudicative mediators. There are mediators that are hired to settle. Absolutely, they have to settle. There are mediators that are hired to be evaluative, so they're critiquing people at the mediation table. But over on the adjudicative side, what do we actually have? Our med arb, our arbitration, our litigation. That adjudicative side, people are attached to paperwork. People are attached to law. People are attached to contract obligations. When we move to the left